Ethics Board. There are five items on the agenda. The first, which is reorganization. This board hasn't reorganized that I'm aware of for at least 10 years or maybe more. We have a full complement here tonight. We have an alternate, Joanna Bell, who will not participate, is unavailable. I'm going to act as a temporary chairperson just to elect the chair tonight, and that will begin the meeting.
Objection. As I stated earlier today, we've lodged since Monday.
Could you state your name and address and who you represent for the...
Sure, absolutely. Just in case it's not clear. Daniel Sherry representing Christina Peroni. This is an objection that has come as a result of an apparent refusal to recuse. This was submitted back on Monday, at which time the agenda for this board was for the first time posted. The agenda for the board states that the first act tonight will be the reorganization of this board. It's very important to put this objection on the record before that takes place. So if I have leave, I would like to present that objection now because it involves specifically John Rice, the solicitor, and Elaine Paul Schaefer acting as part of this board with this particular ethics investigation. So with that, I think I'll move right into the objection. Assuming, of course,
Mr. Sherry,
and this offer remains,
Mr.
whether
Sherry,
or not either Mr. Rice or Commissioner Schaefer is going to voluntarily recuse.
we're going to address your request. We're not going to address it right now.
Well,
we
taking place.
We want to organize the board first.
In terms of a reorganization, if votes are going to be cast, I understand, Solicitor Rice, that you do not have a vote as to any matter. You do not under the charter. However, Commissioner Schaefer does. And selection of the leadership of this particular board, if there is an objection as to whether or not she should recuse or should abstain, that should be heard before any vote regarding leadership of this board.
You've just made the objection. You sent an email. Email today.
There's actually a presentation that I think should be part of the record to the extent it should be heard before this leadership vote. I would like to do it now.
Is this a written presentation?
Oh, well, there's certainly documents for you to review as I present.
Well, why don't you hand it up? And
I have copies for everybody involved, so I'll go through this then. Here's a copy for Commissioner Schaefer.
Dennis McAndrews, my firm represents Mr. Spengler. Who is supposed to rule on this? If you can't organize, he's raised an objection. Who's supposed to rule on it?
Right.
If the board doesn't organize? This is absurd. This is the kind of thing that this board should not be entertaining.
Okay, well, I've heard right now the solicitor.
Who's supposed to rule on it, Mr. Sherry?
Who's supposed to rule on it? I think the board before any leadership decision is made. The board is before you right now.
The board
can still rule.
The board's not organized yet, Mr. Sherry.
Are you saying that the individuals?
Rule.
I can't respond to both the solicitor and somebody who just, as I understand, has entered as counsel.
Let us do our business, get organized.
Is that organization going to involve the election of a chairperson?
It's on here, a chair, a vice chair, and a secretary.
Is that going to involve taking a vote from people present?
Mr. Sherry, who's going to rule on your objection before the board is organized? Answer
the question of opposing counsel directly?
After Mr.
This board.
Before they're organized?
Absolutely.
Okay.
Why do they need a chairperson? Why do they need leadership if this is the board, as you've indicated they are?
They've got to organize in order to conduct business. Basic parliamentary
So your assertion is, even though there has been objection raised to Elaine Paul Schaefer participating at all in this process, you're going to allow Elaine Paul Schaefer to vote as to who should be the chair, the vice chair, and the appointment of the secretary. That's your contention?
Why don't you see if she actually votes?
Okay, that's very coy. I've been asking since Monday whether or not there's going to be voluntary recusal. If there's not going to be voluntary recusal, I need to know that now, and then we can move past this. If she's going to recuse, then recuse right now, and we move right past this.
We're going to organize first.
I've stated my objection.
Your objection is in the record, as is your email. Okay, so we're back to the reorganization and the election of the chair. I'm acting, as I started to say, as the temporary chair, and I'd like to call for nominations for chair of this board. Are there any nominations?
I'd like to nominate Bud Hirsch.
Okay, is there any other nominations? Okay. Nominations are closed. Can I have a vote on Mr. Hirsch as chair?
Do you need a second or not?
I'll
I'll
take a
second if you need it.
Sure. Okay. Is there any discussion from the board? Okay, can I have a vote for the chair? From the members that are sitting up here.
I'd like to abstain, please.
Mr. Vines?
Aye.
Okay.
Aye.
Okay. Mr. Hirsch, you are now the chair, and you can move on to the other two reorganization items on the agenda, please.
Great, thank you, Solicitor Rice. The next item on the agenda is the election of the vice chairman. Are there any nominations for that position, please?
I would like to nominate Martin Heldring to serve as the vice chair.
Is there a second to that nomination? Okay, thank you, Bill. Are there any other nominations? Okay, we can take a vote. All in favor of Martin Heldring as vice chair?
Aye.
I'd like to abstain.
Martin Heldring has been elected as vice chair. Congratulations.
Thank you.
And the next item on the agenda is the appointment of a secretary. Mr. Zinkowski, the township manager, has volunteered to serve as the secretary. So do I have a motion to accept the appointment of Mr. Zinkowski as the secretary of the board?
I move to nominate Bob Zinkowski to serve as the secretary for the board.
Is there a second?
I'll second it.
Good. Are there any others? We'll take a vote then. All in favor of Bob Zinkowski as secretary of the board, please say aye.
Aye.
I'd like to abstain.
Opposed? Thank you. Mr. Zinkowski is now the secretary of the board. Thank you. I have a few comments to make before we go on to the rest of the agenda, and wanted to first state that the board's role is stated in the Township Code, and that we are to act as a fact finder, and that as a part of the board's process that we will prepare a report of the findings of fact for further action by the Board of Commissioners, and they will take care of the findings of fact in the manner in which they see fit. The rules and regulations for this ethics board have been approved by present and previous boards of commissioners. They outline the steps to be taken when a complaint alleging an ethics violation has been submitted. Copies of the ethics board's rules and regulations are attached to this evening's agenda. On tonight's meeting agenda, we will accept an ethics complaint which has been submitted to the board. We will discuss the initiation of a preliminary inquiry as provided in the rules and regulations, and we will also receive public comments for which there is a 5-minute limitation on individual comments. We also invite members of the public who have information or facts regarding the complaint to submit such information or facts to the township manager, Bob Zinkowski, who will then provide that information to the board during the course of our inquiry. What I'd like to do now is to introduce Solicitor Rice, who will briefly describe the procedure as set forth in the rules and regulations to make clear what the board's role will be and the mandated steps that we will be following during this process.
Okay, thank you, Mr. Hirsch. The copies of the rules that should be with the agenda in the back of the room, the rules were adopted in 1995 by a previous board of ethics and by a previous board of commissioners. It sets forth basically 3 or 4 general steps. The first step, which is on the agenda tonight, is simply an acknowledgement that a complaint's been filed. Under Section 1A, talks about a complaint and then what the steps are once a complaint gets filed. Chairperson under paragraph 5 is to call a meeting, at which time there's a determination as to going to the next step, which is a preliminary inquiry. Both the complaint other than the complaint, but the board's activities are all subject to confidentiality. It's set forth in the rules. The preliminary inquiry is an inquiry that the board will conduct as a group to determine what facts are relevant to the complaint that's been filed. There's a time period for a preliminary inquiry. I think the board's desire is to move as quickly as possible in terms of talking to individuals, securing documents, and getting other documentary evidence that bears on what the complaint is. All board proceedings and records relating to the board's activities are confidential. They will conduct their interviews confidentially. They will conduct them in private. They will ask for records privately. Anybody that has any information involving the complaint, which has been broadly televised and is available.
It is?
Please.
Sorry to interject. Where is it available?
Please provide that information to Mr. Zinkowski. Anybody that has any information regarding that, please provide that. Mr. Zinkowski, as the secretary of this board, will then distribute that to the rest of the board members. The preliminary inquiry then essentially establishes whether or not there's any cause to move forward to a full investigation. That would be the next step, and then some determination of whether or not the complaint is supportable. This board's role is not as a judge. This is not a prosecution. This is not a quasi-judicial proceeding. This is a fact-finding body, and the board will perform that role in accordance with these rules. The other two issues which I'd like to address, first of all, is the request that Mr. Sherry began with earlier tonight regarding Commissioner Schaefer and her request to step down from participating. We have, Mr. Sherry, your documents. They're in here. These are documents that are they're part of the record of this board's proceedings. They're documents that are, it looks like they run from February 2012 to April 1st, 2014. So with that, I'd ask Commissioner Schaefer just to address that issue.
Excuse
Thanks,
me.
John.
Just as a matter of policy, I was told to hold my objection until there was reorganization. Reorganization has occurred. I would like to present the objection now.
We're not done with the reorganization, Mr. Sherry.
There has been,
When we
under
get-
reorganization, according to this agenda, incidentally, who created this agenda? I'm just curious, who typed this up?
Mr. Sherry, when we're done with the preliminary comments and we get the public comment, you're free to make the objections that you want to make.
No, I'd ask for
So-
clarification here. Reorganization, according to this agenda, has three finite items: the election of the chairman, the election of the vice chairman, the appointment of secretary. I was told repeatedly by yourself and by counsel for Mr. Spengler that there needs to be reorganization before I can present the objection. The reorganization, insofar as this agenda is concerned, is complete. There are no other issues set forth in this agenda after Title I, reorganization, appointment of secretary.
And you're-
Also, what was not noted is the other objection is your participation in this process, Mr. Rice.
We'll get to that, too. We'll get to that.
I understand that, but I would like, if now...
If you can just
know,
refrain for a couple minutes, we will get to both of your objections, and then we will be in public comment, and you have a presentation subject to the chairman's running of this meeting. You'll be free to say whatever you want to say.
I'm going to get a little nervous as to the solicitor acting as parliamentarian. However, I will allow Commissioner Schaefer to say what she wants to say.
Thank you.
Gracious. I am going to step down tonight from this board. The question was raised as to whether I have a conflict of interest for serving on this board. And as everyone who knows me or who has followed the Board of Commissioners meetings for the last several years, I take that very seriously. In past instances, I have gone and gotten an official opinion about whether I have a conflict, and when I get a clear answer, yes or no, I act accordingly, and I've recused myself from several items along those lines. When this was brought up in this instance, the answer was not clear to me intuitively. It's a very complex issue as to whether my conflict with Villanova would apply in this situation for the limited scope of this board. So, like I did in the past, I went and got guidance from people in the field that are at the top of the profession. Unfortunately, this time I did not get clear guidance. I got a very murky, well, maybe, maybe not. And it's not clear. It's a gray area whether there is a conflict or not in this situation. Instead of engaging in a big fight and having this very meaningless distraction that would not get solved because it's a very murky area, I have decided, so that this board can move ahead with its business expeditiously, that I will step down. I am happy to do that. And my colleague, the vice president of the board, has very graciously offered to serve in my stead. He is here tonight. So I am going to literally step down tonight, and Mr. Higgins is going to serve in my stead. And good luck to you all.
Just as a matter of process regarding this, while I would acknowledge that Mr. Higgins does not have the, and I take strong exception to the claim that this is somewhat murky in terms of Commissioner Schaefer, I am not familiar with the process that comes when somebody voluntarily recuses themselves from this board insofar as the person being on the Board of Commissioners. I'm aware during Board of Commissioners meetings when Commissioner Schaefer, for example, steps aside on a Villanova issue because she's conflicted out, that at that time, Commissioner Higgins, as vice president, assumes the position of the president. I do not know if there is a specific process involved, however, that would be distinguishable for this ethics board when the president of the Board of Commissioners recuses herself. So I just want to state that I do not have any objection to Mr. Higgins due to any conflict of interest serving on this particular board. Is there support in the code or the charter for the vice president taking place automatically, as opposed to, for example, having a vote from the Board of Commissioners as to who will be taking the president's place on the ethics board? I just put that out there as a process.
And the board will take that under advisement, I'm sure. Typically, the vice president steps in for the president. There's nothing in the ethics code that addresses this issue.
Okay.
Mr. Sherry, you made a request to have Commissioner Schaefer step down. She's done that. We have a replacement. Let me address your request to me, because I don't intend to step down.
Well, I haven't actually presented it yet, so how about if I present it first and then you can address it? Because
No, I'm gonna-
as I stated,
Mr.
first and foremost,
Sherry-
you're not parliamentarian. You're not parliamentarian. I would respectfully ask the chair to allow me to present my objection regarding the solicitor. It will take no more than 5 minutes, and then the solicitor can address it. Because contrary to what the solicitor stated, I don't believe that the ethics complaint has actually been posted on the Radnor Township website or any other document repository where people can go and view it. Just as an example. So while I understand that the solicitor may very well want to address my objection, which I am fairly confident has not been posted to the Radnor Township website or any other publicly accessible document repository, I think it's important for people watching this meeting to understand what that specific objection is and the documents before Solicitor Rice frames the issue the way he would like to frame the issue.
I'm fine with your making the presentation of the objection as long as you stay within the 5 minutes
I shall.
that you mentioned. Thank you.
I shall, absolutely. I will pass out now to this board some documents that I would like you to consider regarding Solicitor Rice serving in the role as an advisor, or as an assistant, I believe the term is, for this particular ethics board. I will, with your permission, pass this up.
Mr. Sherry, just one point of order. This is an ethics board proceeding. So the issues of my involvement or even Ms. Schaefer's involvements, they're not ethics complaints, correct? They're
I
not.
have been given leave from the chair of this organization, this board, to present the objection. I'm going to continue
I
with
just
it
want
unfettered.
I want the
Thank you.
board to understand
You
what.
have time to
what-
respond to my objection. I have a 5-minute time limit. Please let me present this
I'm
objection.
just trying to
sir.
understand under what jurisdiction you're presenting a recusal motion for the township solicitor in front of an ethics board.
It's interesting that you talk about jurisdiction because that will dovetail into the first point I'm going to make regarding this objection. This board is tasked with following Radnor's code and Radnor's charter. When we take a look at the statements that Solicitor Rice has made in public, as well as curiously, the affirmative defense that was presented to me tonight by opposing counsel, we see quite a lot of statements regarding Commonwealth law. Solicitor Rice said earlier tonight, you're not even a quasi-judicial body. You are not here to act as the Commonwealth Court of the Pennsylvania Supreme Court. So I'd like you all just to focus on the language of the charter and the code, and specifically the factual timeline in this case in terms of public statements made by Solicitor Rice, and determine whether it's appropriate for him to stay as an assistant with this particular board. The first document in this packet that I've handed out to you goes back to January of 2014. It's titled, and it was published in Radnor Patch, Radnor Commissioner, I have no financial interest in Villanova University, and I've highlighted it for your convenience. It's January 6, 2014. And the first page, you can read it at your leisure to the extent you haven't already, deals with the photograph taken of Commissioner Spengler wearing a staff jacket and working at a Villanova game. The second page, however, involves comments made by the solicitor to the press. It states here, but being a graduate, being a fan are not legal conflicts, Radnor Township Solicitor John Rice told Radnor Patch Monday. The state ethics statute focuses on pecuniary benefits, Rice said. Quote, I don't know if it would be an issue, end quote, he said of Spengler's volunteerism. Quote, I'm not aware that there's any legal conflict. Rice said that when it comes to leaders in government, quote, people tend to think just because you're biased, it's a legal conflict, parens. To be clear, Rice was speaking in generalities and not claiming that Spengler has a bias. Now, we start with this particular document just to show that this is at a minimum on the solicitor's radar back in January. The next document in this packet that I'd like you to take a look at is the March 31st, 2014 televised Board of Commissioners meeting, and I've transcribed this exchange that occurred. You will all remember that was the night where the CICD ordinance was enacted. Commissioner Booker, quote, are there any proceedings or other items that would preclude anyone from voting on the CICD? Solicitor Rice, well, Commissioner Schaefer is conflicted out. She's already announced that. But other than Commissioner Schaefer, the answer is no. And then there is, as I indicated in italics, some brief commentary from, by a resident about certain amendments to the CICD proposed by 7th Ward Commissioner John Fisher. Then it goes back to now board member Jim Higgins. Do we want to finish this issue of Mr. Spengler first? What I want to do is go back to the audience after we resolve the Commissioner Spengler thing, and then everyone in the audience can comment, speak on the main ordinance 2013-21, and when that is finished, all finished, they won't be satisfied, but they're finished, then it will go to Commissioner comment, and when the Commissioner comment is over, that's it, we're going to vote, all right? And then he acknowledges Solicitor Rice, please. Solicitor Rice. Well, I answered Mr. Booker's question already. I think I answered it, so there's nothing else to say on that point. Now, I have no idea what occurred between January 6, 2014 and March 31st, 2014 that would allow Solicitor Rice to make that type of a comment. What was reviewed, what was discussed. But I have a suspicion that if something was discussed with him one-on-one with Bill Spengler, and I don't believe you've acknowledged whether that has even occurred, as is your right. I think you've actually used attorney-client privilege. That would then be the equivalent. If Commissioner Spengler went to Solicitor Rice, that would be the equivalent of somebody representing a party in litigation and then midway through that same attorney becoming the law clerk for the judge. It's totally inappropriate. You don't have somebody going to you for legal advice and then becoming part of the overseeing recommendation body that's going to decide whether or not to recommend to the Board of Commissioners whether a conflict has occurred. Now, we actually do. After this March 31st, 2014 transcript came about, we do know that something did happen during a personnel session by way of what John Nagel told the Mainline Suburban Life. That's the next document in here. Excuse me. The next document just reflects that after a go-ahead from Township Solicitor John Rice Monday, Spengler then cast one of the 4 deciding votes in favor of a new comprehensive integrated college development zoning ordinance that will allow the university, that's Villanova University, to build a new dormitory, performance hall, parking garage, and retail space on the south side of Lancaster Avenue. But now let's take a look at what John Nagel told the press about what was discussed with Solicitor Rice before this vote. And that is with the title, Ethics Complaint Against Spengler Over Villanova Project Continues to Royal Radnor. It's dated April 9, 2014. I've highlighted for you. Asked why the BOC hadn't waited for the Township Ethics Board to investigate Peroni's complaint, which, as you all know, was filed before the CICD enactment vote. It was filed the Friday before. Complaint about Spengler. Nagel said the board met with its solicitor, John Rice, in executive session as a, quote, personnel matter, end quote. Rice explained that the risk of the board's CICD vote being overturned was, quote, minuscule, even if Spengler were to be found in violation of ethics rules. Nagel said the complaint would, quote, not stand the test, end quote. And for the CICD vote to be overturned, someone would need to file a lawsuit. Quote, we discussed it and we understood the risk, said Nagel, but he added, I'm an engineer, not a lawyer. So what's that? It's a demonstration that there was strategy discussed regarding Commissioner Spengler's potential conflicts of interest and what could happen if this vote still went through, and who was part and parcel to all of that and apparently giving advice as to what could happen? John Rice. So again, how can he possibly serve as an assistant of this particular board to evaluate whether or not Commissioner Spengler did anything inappropriate? It's completely farcical. Last statement that's in here, again, is an April 23rd, 2014 article, just came out yesterday, where Commissioner Fisher is interviewed, and he again states that when they voted for the CICD, members of the BOC were, quote, under the assumption that Bill didn't have a conflict, Fisher said. Also, Township Solicitor John Rice agreed that Spengler could vote. So this is not a situation where an ethics board is investigating potentially problematic conduct where the solicitor was hands-off. No, the solicitor appears to have been very much involved. It's not only fair for the complainant, Ms. Peroni, to have Solicitor Rice now involved advising and assisting you, it's truly not fair to Bill Spengler. And here's the reason why it would not be conceptually fair to Bill Spengler. Bill Spengler went to John Rice in confidence. I don't know if he did or not, but assuming he did, and he gave information to John Rice, and John Rice provided him legal advice regarding whatever the situation is with Villanova University, then John Rice is in possession of that information, and you all are deciding the merits of Ms. Peroni's complaint and any affirmative defense that Mr. Spengler raises. It's inappropriate. People that have this type of knowledge as to these particular issues, including, for example, finances with Villanova University, as we just saw with Commissioner
I think
Schaefer.
we're getting over the 5 minutes, so would you try to wrap it up?
I'll sum up.
soon?
Again,
Thanks.
I believe that in a minimum, if John Rice refuses voluntarily to step down, I think it would be appropriate for this board to give a vote of confidence or no confidence, just so the people of Radnor Township can see whether or not, despite this rather robust record that's just in the press, that John Rice should be serving in any capacity with this board when you could nip this in the bud early on and decide, sorry, Mr. Hirsch, didn't mean to use nipped in the bud inappropriately there, given your first name, but that you can nip it in the bud so that there will be no reason for anybody watching this process to think to themselves, are people coming into this with knowledge that the rest of the public doesn't have? That, again, is the reason why we have an independent ethics board. Thank you very much.
Thank you very much. And you're finished with your public comment, so would you mind sitting down so that Mr. Rice can do his presentation?
Sure.
Thanks.
And I'm going to be brief. Mr. Sherry's presented some newspaper articles of various people quoted by, in the newspaper articles. The request for me to recuse myself, there's no legal basis for it. I understand why the request is made, but there's absolutely no legal basis for me not to be involved in this. The ethics code requires both me and the township manager to participate and provide support. This is a fact-finding body. This is not we're not going to have a trial on this case. This is not a prosecution. This is a fact-finding body. Plus, I don't get the vote. I don't get any vote in this. I don't get any vote on the findings of fact. I don't get a vote on anything that goes to the Board of Commissioners. And this board can certainly ignore me. If they ask me questions, I give them advice or suggestions regarding what's required under this charter. They can choose to ignore me or not. They're not bound by anything that I have to say or don't say. The charter also, I'm sure we'll hear a lot about the charter, but the charter does talk about what the township solicitor's role is and what my duty is. And Section 606 of the charter states, the township solicitor shall serve as the legal advisor to the board, to department heads, to administrative officers, to boards, to authorities, commissions, except as otherwise provided by law. So I'm obligated to sit here and to participate in this. I also have an obligation to the township and its residents to make sure that this process, excuse me, doesn't get tainted. This board is supposed to act in a confidential manner, and I'm confident that the people that are sitting up here will do that, and we'll get all the facts. There's been newspaper articles submitted. They haven't spoke to anyone yet. They haven't looked at any documents other than what we've looked at tonight. So the final issue is I'm not representing Mr. Spengler in this case. He has separate counsel. I'm subject to a whole separate set of rules involving attorney conduct and representation. And I intend to abide by those. There's nothing in the rules, there's nothing in the law that requires me, or in this charter, requires me not to participate. So I do not intend to step down. Certainly, we can talk about this outside of the meeting if any of the board members has a concern about that going forward. We've already talked about this, I think, outside of the meeting.
Excuse me, there was a meeting outside of this meeting? That was not announced at the beginning of this meeting. Was there a prior meeting of this ethics board?
There was a prior meeting of the ethics board.
Who was present?
Let me finish, Mr. Shaw. I'll give you all the details.
2 weeks ago, is that what you're looking, time frame?
Is it Monday or Tuesday?
I could check my calendar, but I would say 2 weeks ago, roughly, rough order of magnitude.
There was a meeting of this board prior to it reorganizing. Once the complaint was filed, Mr. Sherry will get you the date. All the board members participated. This is the last thing I wanted to announce tonight, the announcement of that meeting.
Why?
Pardon me?
Why? Why was that the last thing you wanted to announce? Was this meeting advertised?
No, let me finish, Mr. Sherry.
Wasn't advertised, okay.
Let me finish. Wasn't advertised, not required to be advertised.
Why not?
Under the Sunshine Act, there is an exception for investigations. It's in 7085 of the Sunshine Act. And the board met once a complaint was filed, because this board had not reorganized at that point.
So an unreorganized board met 2 weeks ago.
Let me finish my explanation, Mr. Sherry, and then you can.
I'm just taking this down.
So-
This is new to me.
So, well, that's because this is the first meeting. When you have an executive session that's covered under the Sunshine Act, you either have to announce it before it occurs or the first meeting after it occurs.
And did you announce it at the beginning of this meeting? Is it on the agenda that it occurred? The agenda was posted on Monday. I might have had some questions about that meeting.
I'm sure you would. But here, let me just finish. Under the Sunshine Act, one of the exceptions is to review and discuss agency business which, if conducted in public, would violate a lawful privilege or lead to the disclosure of information or confidentiality protected by law, including matters related to initiation and conduct of investigations of possible or certain violations of the law and quasi-judicial deliberations.
You said this isn't a quasi-judicial deliberation. So what's your basis? What's your basis?
I think it's an either-or, Mr. Sherry. Read the
Okay.
statute, and if you have a question,
Well, no, now I have many questions regarding this particular meeting. We have a
So-
commissioner
Well,
tonight who recused herself from
Mr.
this particular...
Sherry,
Let me-
Mr. Rice is supposed to be giving
just
his
finish that
presentation.
announcement.
So please sit down and let him finish, and then, you know, if you have comments, again, in public comment, you'll
Thank you,
be
sir.
welcome to make them.
I appreciate that.
so in order to comply with the Sunshine Act, I'm announcing that meeting. We'll provide the exact date.
April 7.
April 7th. And all board members except the alternate, Ms. Bell, were present. And I'm announcing that as is required under the Sunshine Act. So that's all I have to say. I do not intend to step down. And Mr. Chairman,
Okay, thank you very much, Solicitor Rice. The next item on the agenda is the public comment section. I ask that you try to keep to the 5 minutes. Mr. McAndrews, would you like to speak?
Dennis McAndrews, together with Joseph McGettigan,
Great.
on behalf of Mr. Spengler.
Good. And what is the normal procedure on public comment? Do people line up? Is there an order, the way that works? This is my first time for this. Does it, people just come up when they can? Okay. Go ahead, sir. I apologize.
Thank you very much, Mr. Hirsch. As I said, we are here on behalf of Bill Spengler. The first thing that anybody has to do is keep its eye on what the inquiry is about. It's amazing in the first half hour tonight that we've heard everything about anything other than what this inquiry is about. The Ethics Code talks about present conflicts of interest when you're voting on something. Mr. Spengler was never an employee of Villanova University, never received compensation from Villanova University, organized a volunteer group to work for an outside contractor, Event One, at basketball games, and all contributed their money to the Wayne Little League. How that's a present conflict of interest is utterly beyond any comprehension. It's simply unfair. What we have here is an absolute end-run collateral attack upon what was a democratic vote. Some people liked it, some people didn't. But if you don't like it, you do it at the ballot box, you go to the next election, and you elect people who you want. You don't accuse people of ethics violations. You don't accuse people of wrongdoing when it has nothing to do with nothing. I'm handing up our this is an informal body. It's a letter answer to the allegations, and connected to it is an affidavit from Villanova that neither Bill Spengler, William Spengler, or the Spengler Agency has ever received any compensation from Villanova. That should be the end of the inquiry. It really should. On its face, these allegations have no merit, they have no basis, they're wrong in fact, they're wrong in law, they're mean-spirited, and they are outside what this body should be doing, looking at genuine ethical violations. The fact that somebody worked for an outside agency at a game and gave their money to the Wayne Little League, if that's the best ethical violation, no wonder it's the first time this board's met in 8 years. It's amazing. In these materials that I'm respectfully presenting tonight. I note that the burden of proof is always on someone complaining and making an ethical violation. And under the state ethics code, that burden of proof is exceptionally high. It's clear and convincing evidence, which is defined as evidence so clear, direct, weighty, and convincing that enables the trier of fact to come to a clear conviction without hesitance of the truth of the precise facts at issue. You know, when you steal somebody's name by accusing them of an ethical violation, it doesn't matter whether you agree with their politics or not. That's not, hopefully, what this is about. I think it's what it's about in terms of the complaint, but it should never, ever be about adjudicating whether someone has violated their ethical obligations. I remember from A Man for All Seasons, Thomas More says, when a man takes an oath, he holds his life as if it was water in his hands. And you can't expect, if you violate that oath, to see your hands, your life in your hands anymore. And that's what this is about. You have your obligations. Mr. Spengler has his obligations. Unfortunately, people who make complaints really don't have much obligation at all other than to throw stuff up and hope that something sticks. And that's just wrong. It's not fair, it's not right, it's outside the pale of what this body should be doing. And to claim that someone who got no compensation from that university, who never worked for that university, and who gave the money from it, did something wrong, and by the way, he even resigned from the outside organization before the vote was taken. That no need to do so, but did so. And again, the ethics law, as Mr. McGettigan keenly pointed out to me in looking at it yesterday, is all about present conflicts. When he voted, he had no conflict of any kind. So I very much appreciate the opportunity. I actually have another engagement or matter at 7. Mr. McGettigan will be here to answer questions if need be. And may I hand up the...
Certainly. Thank you.
Thank you. May I pass it to the various board members?
Sure, thank you.
Okay. Dan Sherry for the complainant, Ms. Peroni.
Would you wait until he's finished, please?
Oh, I'm sorry. You passed them all up? Well, good. I do want everybody to take a look at this because it's important. We heard just in that admittedly concise presentation, quotes from A Man from All Seasons, statements about Commonwealth law. I'd like everybody to take a look at this letter brief that was submitted and see whether there is any mention of Radnor's Code or Radnor's Charter in that letter brief. It won't take you long. It's not there. It's not there at all. Why would somebody be coming in here quoting to you Commonwealth law? It sounds an awful lot like what John Rice was telling Radnor Patch back in January. So when we hear from opposing counsel, keep your eye on the ball, Ms. Peroni's complaint, her supplement, her second supplement, all of them relate exclusively to Radnor's Charter and Radnor's Code, the only law that this board is qualified to look at, not application of Pennsylvania Supreme Court precedent or a Commonwealth Court precedent. So this is, to me, flabbergasting. Now, with respect to the affidavit that was submitted, because again, this doesn't address at all Radnor's Code. You all have seen the complaint. Let's go through it relatively quickly. Because again, I understand Mr. McAndrews has someplace to go. And he said that he's read the complaint. This is the March, let's see here, 28th, 2014 complaint. Incidentally, that was prior to the March 31st, 2014 CICD ordinance enactment vote. So a little tough to have preemptive sour grapes, I'd argue. The areas of inquiry that Ms. Peroni requests involve specifically Event 1. Specifically,
Mr.
that's
Sherry,
number 1.
are you going to read the whole complaint? Because the board's read it.
Okay. Well,
And
Mr. Rice, actually, you know what? I'm going to call you on the carpet now. Do you actually have these complaints posted on the Radnor Township website or not?
Do I?
Yes, you stated that they are publicly available.
You published them in the newspaper.
I published them in the newspaper. They're available on the Mainline Suburban Life or the Delaware County Daily Times website.
I can't tell you whether the township
All right,
posted it.
let's think before we
This
speak.
is a public comment period,
So-
so
so
please
I-
go ahead.
I would,
Don't question
without the-
Mr. Rice.
Thank you.
Let's just go
I
ahead
had to
and
respond to a direct
introduce the
statement by
five-
Mr. Rice.
I understand,
But again, this particular complaint is predicated on the following. Radnor Home Rule Charter, Section 9.05, 9.05A2, 9.05B, 9.05D, 39/5A of Radnor's Code, 39/5B3 of the Code, 39.9 of the Code. Submitted back in March 28th. Practically a month's passed. Radnor Code, Radnor Charter referenced? No. Wonder why that is. Wonder why that is. What's the charter say with respect to conflicts of interest? No elected or appointed official of the township and no township employee shall engage in any activity which follows: 2, solicit or accept, directly or indirectly, any gift, favor, service, commission, or other consideration that might reasonably tend to influence that official or employee in the discharge of the duties of office. Acceptance, not simultaneousness, acceptance. And what is the acceptance that we're talking about here? $60,000 to $80,000. That's what's been reported in the press. Commissioner Spengler has stated that that was routed to the Radnor Wayne Little League, but from what we all know last week, you've seen it in the second supplemental complaint. Actually, I think it was in the first supplement, that that money may have gone into the Radnor Wayne Little League account, but Commissioner Spengler took money out of that account. Checks were cut to him, over $5,000 worth. That's the direct and indirect acceptance that we talk about. So while, again, I understand the desire to shift this into an inquiry as to Pennsylvania Commonwealth law, this is the charter, this is the code. Those are the governing documents. Anybody who comes in here and tries to present different law, as my grandmother from West Virginia would say, pour that person out. It's irrelevant in terms of what this board should do. Now, on the subject of employment and incompatible employment, we know from Commissioner Spengler's comments to the press that he was actually under a requirement to provide ushers at Villanova University games, 13 of them. He had to pay them out of his own pocket. And after he did that, dipped back into the Villanova ushering fund at Radnor Wayne Little League. This is all admitted by Bill Spengler. So again, for people to come in here and say, just throw stuff on the wall and see if it sticks, this is all a matter of public record. It's Bill Spengler's admissions. This isn't a witch hunt. It's not a fishing expedition. Every single component of Ms. Peroni's complaint and all of the supplements are predicated on Radnor's Code, Radnor's Charter, and statements made by Bill Spengler in the press, not from personal knowledge on her own behalf. She hasn't spoken to Bill Spengler and said, hey, Bill, what'd you do with the money? There's nothing about that. She wasn't privy to any private conversation Bill might have had, Bill Spengler, just to be formal for the record, may have had with Villanova University. No. This is about the press and what's appeared in the press. Bill Spengler showing up at Villanova basketball games wearing a yellow staff jacket. Bill Spengler telling the press that $60,000 to $80,000 has been paid, be it routed to the Radnor Wayne Little League. And incidentally, about that charitable contribution, as we've stated quite specifically in the press and in the complaints, there is no provision whatsoever in Radnor's Charter or Radnor's Code that states that a charitable contribution destroys a conflict of interest. Anybody, I expected that tonight. Bill Spengler had an attorney. I expected that attorney to come in tonight and show me something in Radnor's Charter or Radnor's Code that I had just overlooked, saying, got it all wrong, Mr. Sherry, got it all wrong. Take a look at Radnor's Code. You can eliminate a conflict of interest if you charitably contribute. But obviously it's not there. This board would never want to get itself into a circumstance where it has to subjectively evaluate charities. All it's looking at is whether there's direct or indirect acceptance that might reasonably tend to influence the discharge of official activities. If you believe...
Getting close to wrapping up. We've
no more
well past
than
the
a
5 minutes, but I didn't want to...
No more than a minute. No more than a minute. With what is presently in the press, the amounts of money, you've all seen the spreadsheet from the Radnor Wayne Little League. You've all heard Bill Spingler's explanation about his requirement that he has to bring in ushers for these Villanova games and has to pay them out of his own pocket if he can't get volunteers. There is more than enough evidence already in the public sphere that should justify this particular ethics investigation going forward. Thank you for your time and your candor.
Thank you. I do want to just mention that our mission of our board is one of fact-finding, and that although a lot of things have been said tonight about items that are in the newspaper or comments or whatever, we're going to be needing to get the actual facts from people, and that we will be preparing a fact-finding report which will contain the facts. And I don't know, are there other public comment that people would like to make at this time? Is there anyone else? Please come forward.
I'm surprised. There's usually a big fight to get up here to make public comment in this room.
Good.
My name's Jim Yiannopoulos, 15 Braxton Road. Before I get to my formal comments, just a couple of comments on the comments that were made already. I haven't found the complaint or its amendments published in the township's website or any newspaper, so just for that. And with regard to the state ethics code, I agree, that's not what you should be looking at. That's not what we're considering, not what you should be considering. You know, when the March 31st vote was made, Mr. Higgins actually said, hey, this is the way it works. It's the way it works everywhere. It's the way it works in Harrisburg. I shuddered when I heard that. Thank God we're not Harrisburg and that we're Radnor, and thank God our code is stricter than the state's code is about this. Because yes, the state's code does talk a lot about just the exchange of money. There are lots of other ways to be unethical, and that includes exchanging various kinds of favors. Now, the attorney here mentioned that it's been 8 years since the ethics board convened. Some might think, hey, that's a really good thing. That means things have been pretty good here in Radnor government. Actually, it's quite the opposite. The township charter makes it very difficult to bring forward ethics charges, and people don't do so frivolously. The people that have finally gotten so disgusted with how our public officials conduct themselves that they've gone to all this work and trouble is a sign of just how bad things have gotten here in Radnor. For years, we have endured some commissioners voting not on the merits of a particular resolution or proposed ordinance, but on the basis of relationships and long-standing friendships with the parties involved. When these friends come before them asking for variances, legal changes, special exceptions, etc., they ask a few questions, make their attorney work and sweat a little bit, but there's always a point at which their good friend gets a little smile, a wink, or a nod of reassurance, as if to say, don't worry, we just have to appear to challenge you a little to play along with the pretense of a democratic process. But you'll get what you want. I have seen private clubs that are more democratic than Radnor Township is right now. We've also witnessed public officials abuse their power and influence, including misusing the police to intimidate residents who don't fall in line with pet projects and programs, or even if they don't like what they say during or after a public meeting. Over the past year, this kind of behavior has gotten completely out of hand. There appears to be a small group of public officials who believe that they are the ruling aristocracy, and we citizens exist to serve them and their friends. Power corrupts, and absolute power corrupts absolutely. Is Bill Spingler the worst commissioner in Radnor? I think there are two, maybe even three others that are even worse. They appear just a little craftier in disguising their misuse of power and aren't quite as brazen and public about their behavior. I suspect you have a very busy year ahead, hearing one or two additional cases before you're able to clear the smell that currently fouls the air in Radnor. Your work begins tonight with this first case, and we understand that it is not pleasant. If you do your job, you will be delivering the message that a ruling oligarchy will no longer be tolerated and begin to restore the faith of the average citizen that democracy can return to Radnor Township. Thank you.
Thank you.
My name is Colleen Price, and I live at 536 Atterbury Road in Villanova. And I just wanted to follow up on an earlier comment about Mr. Rice. I think you may be right that there may be no precise law that says you should recuse yourself. But back in law school, they always tell us there's a smells bad test, and it just sort of smells bad. You were involved. You were the person, from what everyone is saying, may have given the advice that this was not a conflict of interest, which is really the essence of this whole ethics hearing. So just because you might be in a position where you feel you need to defend yourself, I think it would be better on behalf of the township just to not have you in that position. I know when we had the Ardrossan hearing, we appointed somebody else. I think we could do the same thing in this matter. I think there may be an appeal, and there may be further issues regarding Bill Spengler, and it's really just not worth to jeopardize the township and to possibly spend legal fees because you have somebody who might have an issue. It's just easier to replace him. Thank you.
Thank you.
Hi, good evening, everyone. I'm Diane Edbrill. I live at 205 Spruce Tree Road, and I'm an attorney as well. And to follow up on what Colleen Price just said, I would also like to ask Mr. Rice to reconsider. The reason that the complaint that this board is convened to hear was filed was because there was a conflict of interest, or certainly at the very least reason to believe that there is a serious conflict of interest which was ignored and which resulted in a vote that that the public has no confidence in, and that the public feels was tainted. And I think based on everything, many statements I've heard from Mr. Rice at commissioner meetings, public meetings, and some other statements in the press, it's clear that Mr. Rice is in the center of this. It's certainly very likely that he will be called upon to relate information that he's in possession of as a witness, and that puts him in a very untenable position. I mean, it's his choice, it's his career, it's his decision to make, but I think that also will just simply compound the lack of faith that the public is going to perceive over this whole process. And as Colleen said, there are many attorneys who would be similarly well qualified to do this who do not present that hurdle, that potential pitfall, and that who would negate any perception of bias or taint to this proceeding. Thank you very much.
Thank you. I appreciate your comment. Are there any other comments?
Good evening. My name is Christina Peroni, and I filed this complaint. I did not do it lightly, and I understand the ramifications of filing this complaint, and I took it very seriously. My concerns with this process and with the potential conflict of interest I raised at a Board of Commissioners meeting on the March 24th, before there had been any vote for Villanova. And during that time, I raised issues of Mr. Spengler's relationship, either directly or indirectly, with Villanova, as is stated in our code. That is all I ever care about is a code, because I'm not a real attorney. I just pretend to be one sometimes. So that is the only thing I really understand is the code. And I understand this code very well. And that concerned me. When I brought that up at the meeting, I was scolded by commissioners and told, if you have a problem, Ms. Peroni, Commissioner Schaefer said, if you have a problem with this, file an ethics complaint. It's on the record, it's on the tape. So clearly they did not take the opportunity to investigate on their own. Mr. Rice, during that same meeting, said this is attorney-client privilege. I represent Bill Spengler. Mr. Rice said that he has to preside over this because it's in the charter. Well, the charter also says that Commissioner Schaefer, as the president, has to be a member, and she recused herself. She recognized that it was messy, that it taints the view of this board. You are all volunteers, and you're spending your own time to investigate a very important matter in our township and the ramifications of that matter. And to go and Mr. Rice, I just feel you're not looking out for the interests of the taxpayers, and I believe that is your number one job. Although you said at that meeting that was not, your job was to be the counsel for the commissioners. So I would ask this board, and I would really, really ask this board to consider making a vote on whether or not you want Mr. Rice. Mr. Rice has other counsel in his office that can represent the board. You guys want to have a clean, if he stays on this process, it's already tainted. Every bit of work you do will already be skewed by the fact that he has already delivered that this has to be confidential. That is not true. It does not have to be confidential. It says nowhere in the charter it has to be. They found some old rules. Well, you guys can create new rules. That was from 10 years ago. The only way to guarantee openness and to guarantee that this is a trusted process is out in the open. We're not looking for Mr. Spengler's Social Security number. We're not looking to go and analyze everything. Some documents would have to remain confidential. I respect that. But the deliberation and conversations that happen, let's say in executive session, that were personnel matters, but yet they aren't personnel matters that Mr. Rice resided over, those are conflicts that are really important, and we will call Mr. Rice as witness. How can he be a witness and also a member of this board? So that's number one. I would ask you to
witnesses.
But if it's fact-finding, we're going to have to ask some people about facts, and you...
When you say we, you don't...
No, I mean this board.
This board will decide who they want to speak with, what documents they want, and they'll have people come in that they will question about the facts. So there's no calling of witnesses in the traditional sense.
It's interesting you say that, Mr. Rice. You requested, actually, that my client verify her complaint. To the extent my client provides testimony before this board, I am going to insist that a court reporter be there and this be stenographically transcribed. My client will not be subject to the rules of perjury based upon recollections of people in non-videotape meetings. I would hope. In yesterday's newspaper article, John Fisher stated that he was willing to be a witness for this ethics board. I hope and I expect that this shall be done in public whenever possible. Again, if it's Mr. Spengler's personal tax records you want to review in camera, have at it. For people that I represent and witnesses that I believe you should call, and representing the complainant, I believe that I would have the right to call witnesses and support the allegations in my client's complaint. We are going to request that that be done in public, or at the very least with a stenographic record, which then we will release to the press. This is very important that we have
Mr.
as
Sherry?
much sunshine on this particular investigation as possible so that we don't have another circumstance potentially with what went on apparently before the CICD enactment vote. One last thing real quickly about the votes.
Mr. Sherry,
because this was not made
Sherry,
clear
on the-
earlier, but it
on-
was specifically addressed. You
Mr.
can address my comments after I speak.
I just have a question about doing this in public. What about the rules that say it's supposed to be confidential?
Rules
How
that
do
say it's
you-
supposed to be confidential.
How do you suggest this board deal with rules that are in place that are valid?
Sure, because we're talking about
Are we
hearings.
ignoring-
There's a specific hearing section. There's a specific
are we
hearing. I'm addressing your
ignoring them?
question directly. There's a specific section in the rules regarding hearings. And actually, it's up to whether or not the person being complained of wants to have it be a public or private process. Now, on that note, John Nagel specifically told the press this should be a public process.
Well,
Said it
let's-
in the article
let's-
that you have before you. I want to address your question in total,
Stay
Mr.
off
Rice.
John Nagel and tell us about what's
off-
in
stay after John Nagel.
in the rules.
I
What
just
does
said
it say
specifically
about
the hearings. The hearings can be convened in public or in private at the behest of the person being complained of. That's the rule that you're submitting. It says
Okay.
that in the hearings. Now,
So how do we get around that
okay, now
to honor?
Bill Spengler is not here tonight. Doesn't appear to be here.
I represent Mr.
Okay. Well, maybe we'll get a representation right now whether Bill Spengler, who has been very forthcoming with the press about these documents, wants to have the hearing in private should it go forward. Please.
Mr.
I'm going to say something now because
Well,
I was invited.
Well, just a moment. Can we let them finish first?
Oh,
and then
I
you're
yield
wa-
it. He can certainly.
Well, you don't
But,
have
okay,
the
well, then I'll
floor,
make the last
Mr.
point then
Sherry.
about what I specifically said about votes, because this is important. A statement was made, I believe, by Mr. McAndrews about Bill Spengler. He cautioned it, said he didn't have to stop what he was doing in Villanova, but he did before the vote. Really? I seem to recall that it was back in January when this ordinance was first voted upon. And did Bill Spengler vote? Let's take a look at the record.
Okay, I like the soundtrack.
Okay. These were all submitted to you also with the, as part of the packet for why Elaine Paul Schaefer should not vote. Oh, excuse me. It's actually part of the complaint. January 6th. This is page 1, 2, 3, 4, 5 of the second complaint. This is just heading off what we anticipated the defense might be. It said, insofar as inapplicability, even if the I quit in February 2014 defense had a shred of substantive validity, and it does not, it would provide no relief whatsoever to Commissioner Spengler with respect to the CICD. This is because on January 6th, 2014, Commissioner Spengler voted on Ordinance 2013-21, set hearing date, amending Chapter 280 of the Radnor Township Code Zoning Ordinance by establishing regulations for new comprehensive integrated college development use within the PI Planned Institute District. C, Township of Radnor, minutes of public meeting of January 6, 2014. Oh, and by way of comparison, reading on Elaine Paul Schaefer, who has publicly acknowledged a conflict of interest regarding Villanova University, abstained from voting on the CICD on January 6th, 2014, just as she did on March 31st, 2014. So just wanted to clarify, in case anybody is here operating under the auspices that it just matters what he does in February regarding the CICD, think again. It goes back further than that. It's on the record. Thank you.
Thank you. Did you want to finish, Ms. Peroni? Sure.
Thank you, Mr. Hirsch. So I would ask this board before the conclusion today to take a vote on whether or not you think it's the right process to have Mr. Rice stay on board. I know that's uncomfortable, and democracy is uncomfortable, and it gets stinky sometimes, and that's hard. But you guys agreed to be here and do some hard work, so I ask you to do that. Standing here is also hard work, and I have already been called frivolous in my complaint, and there is nothing frivolous in what I would do. So I would ask, again, this board to vote that my entire complaint is online. Mr. Rice said it was. It is not online. I've been online.
Wait a minute. Just.
You
didn't-
said it was online.
I said it was published. Mr. Sherry challenged that, said, why isn't it online? The question, which I think the staff, and that's why I got up and talked to Bob and Jennifer, is whether or not, since there's a confidentiality provision in these rules of any of the proceedings and any documents that this board receives, whether or not they would be violating that by putting it online. Now, you have the right to publish it, which you have.
We have
the right
not
to
published the entire document. There's a lot of substantive information. There's been a few lines in the paper. That's not...
But it's a question that this board, I know, has a concern about in terms of them...
Who's the attorney here?
them breaching the confidentiality of their own rules.
Mr. Rice, just a little recent history. You specifically stated, go read the complaint. If you have information, come forward. You said that for people regarding this particular complaint. So if it's not published,
But what's that have to do with posting?
Your invitation...
Mr. Sherry, stay on posting on the website.
Sure, I'll stay
Tell
on
me
that.
what authority this board would have, or the township, to put any documents, not just a complaint, on the website when there's a confidentiality clause in here. How do we get around that? How do we get around that?
You want to talk to me about confidentiality? Remember Lehman Brothers?
No, the
Your
rules.
idea to have that it was confidential for that settlement?
Mr. Sherry,
let's make very clear as to how little I respect your views with respect to confidentiality.
You're not going to answer the question.
No, my specific response to you, Mr. Rice, is you invited people with information to come forward based on what was in the complaint. If it's not published, how do you expect them to do that? If you would like, Mr. Rice, I will request that the mainline media news publish the complaint, the supplement, the second supplement, the third supplement, and then I don't know what you can do in terms of direct people there. I guess I can reach out to people and tell them to look there. But if you're truly stating in good faith that you want people to come forward who have information based on the language of the complaint, and then say, where's the complaint?
We probably heard enough on this subject for right now. Good, Ms. Peroni, did you want to conclude?
I do want to conclude. I ask this board to please consider very strongly whatever can be done in the public. We need to restore some confidence in this process. And also it has to do with my reputation. I have worked very hard on this charter. I was on the Charter Review Committee. I understand the rules as laid out in this charter. And I would not have brought forth this complaint if I did not think there was a real violation of this charter. So when we ask for other people to come forward, if no one really understands what the complaint is, then how is it possible for other people to come forward? My last point is that Mr. Fisher has also brought up that during executive session, it sounded like Mr. Spengler has changed his story multiple times. That is an important fact that needs to come out. So I would ask that you make sure that you speak with Mr. Fisher and that he's part of it. Everyone who's given comments should be part of the process, because if it's fact-finding, part of what you have to do is hear evidence, which Mr. Rice is someone who's got evidence. So again, I would ask you to do something very uncomfortable and vote as to which of you feel Mr. Rice should stay on board. Thank you, Mr. Hirsch.
Thank you. Yes, we have another comment. Thank you. Mr. McGettigan, did you want to speak, or do you want to wait till after this?
Council, I assume.
No. No, just Al Murphy, Glenmurray Road. For the record, I don't have a law degree, but I'd like to make some observations on this cat fight, which I've been in this township for a number of years. The standards, I'm in the financial services industry. I've been for 30-plus years, been involved as a volunteer on the township. People know me pretty well here. The standards that have evolved over the years are, I think, a little bit stricter than anyone on the panel or in the audience would like to acknowledge. And where it's gotten stricter, I believe, is it's not just, and we can argue the facts, I mean, this cat fight that's going on about who's got the facts right, I find very interesting, because the standard that we operate in my industry, the standard that I believe is sort of spreading out across the political spectrum as well, is it's not just that there's a conflict of interest, is that there's an appearance of a conflict. Now, that's a pretty difficult standard, and when you're confronted with that, you really change your behavior tremendously, from everything from entertaining to what you do, and it's whether it's whether a union, political spec, whatever it would be, financial services, it's the appearance of conflict that's really been such a standard today that most people are operating under. And to a certain extent, and I've known Bill a long time, he's brought this disease on his house by his own hand. Everybody in the township knows that Bill loves Villanova. He's been active, he's been volunteering, his votes, I mean, it's been true for as long as I've been in the township over the last 30 years. That's not a surprise. But he really brought the hammer down the night that they were arguing over whether the development was going to be subject to code, and he opines, you know, in Bill's own way from the chair, and says, don't worry about the code, we'll simply pass an ordinance. So what we have is, we have someone that we know, everybody knows Bill loves Villanova. He opines from the chair that, don't worry about code, we're gonna impose an ordinance, and ordinances have been used across the township to do a lot of different things over the last few years. But he starts down this road of basically indicating to Villanova that the deal is done, and I've had friends that were advising Villanova on the design that said, once he said that, you're in, the deal is done. And then we come to this and we find that there's a little bit of other stuff happening behind the scenes due to his volunteer work and the money flow, the fact that I think it's a good point that it was donated to charity, doesn't necessarily obviate the appearance of a conflict. But the standard here is such that with Bill has put himself in this position, the fact that he's been voting all this, and this is a very controversial vote that was passed about Villanova, he's put himself in this difficult position, and now you have to sort it out. And the issues with John and what he's got in terms of his position, there's been a lot of stuff that's been said, attorney-client privilege, and we've been doing things behind the scenes. I don't necessarily agree with that. This is a public body. So what I encourage you to do is you're going to look at the facts, but you have a real problem here is that the standard has changed and Bill has put himself in this position. Quite frankly, he should have recused himself from the Villanova votes really from the beginning. Thank you.
Thank you. Appreciate that.
Sarah Pilling, 29 Garrett Avenue. In 2003, Commissioner Dave Cannon was brought before the Ethics Board. I believe the charge was made by a fellow commissioner. And Dave sat here in this room, and we sat in this room, and the entire hearing was done in public. And then they made their decision. There was never any confidentiality incurred. It was all done in public, John. It was excuse me, I'd like to finish.
Yeah, I think it might have been his choice, though. That's, I mean, as Mr. Sherry said, there's a
All right,
choice, yeah.
but it was done in public. The issue was resolved. There was an agreement, and we moved beyond. As a resident of this township for 32 years, where people say to me, why do you go to all those meetings? I have sat in these meetings for at least the last 20 years. Your decision is going to affect the integrity of the township, the veracity of the Board of Commissioners, and I suspect that if the decision goes one way or another, no one is going to believe anything the commissioners decide to do unless this issue is cleared up in public. Thank you.
Thank you. Thank you. Are there any other public comments? Did you want to speak, sir?
Very briefly, if I may, sir.
Sure.
Thank you. Good evening. I really don't have anything to say about the substance of the matter at this time. I think my colleague addressed that. This is the first time I've appeared in Radnor Township, and I just wanted to say I appreciate that. And if I may be so presumptuous and forward as to commend you on your extraordinary patience. And I also want to remark on the citizen comments, some of which I disagree with in substance from what I know of the matter, but I thought they were considered, they were well delivered, polite, and courteous. And Ms. Perrone, whose complaint I have read in detail, and I would be happy to spend some time, my own time, to explain with her why I disagree with her. I thought her remarks were well delivered. But I would be remiss if I failed to point out, I don't know what this fellow was doing. Because I've never been in a hearing before a body which listened attentively and politely as you did, and seen such a discourteous and impolite representation of a side of an argument. And I would be remiss if I failed to make that point. And I'm going to sit down after that. And I've never met any of you gentlemen. And you sat there and listened. The only thing I just wanted to clear up, Mr. Rice, you will not participate in the vote of this body, will you?
No, I don't get the vote.
That's what I mean.
Right.
You are here because it is your function to advise various elements of the municipality.
Correct. I mean, I read from the charter and what the charge is.
And they are each independent actors and will vote as their conscience and the facts require, I would assume, whether it is consistent with your advice, divergent from your advice, or contrary to your advice. They are free to vote as they choose, are they not?
I've spoken to all of them over the last couple of weeks, and I don't think I could convince them of something that they don't believe in.
It is your duty, it is your job to offer advice, and they can do as they will after that. Thank you very much. I have nothing further. Thank you.
Point of clarification regarding what just came out of Solicitor Rice's mouth. And by the way, it's perfectly fine that you take issue with the way that I present myself. I usually find that if somebody is trying to switch the discussion to the person making the argument, it is a sign of desperation rather than strength. But I will just leave that lie for now. Solicitor Rice, you just said you've been speaking to members of the Ethics Board for a couple weeks now. Would you mind describing what you meant by that?
I would mind, and I'm not going to describe anything.
Let's just stop that line of questioning.
I apologize,
Sherry.
Mr. Hirsch, but it is very important to me in terms of process whether or not there were prior meetings, or for that matter, if people were contacted by the solicitor separate and apart from deliberating as a board. That is very disconcerting to me as someone who represents a complainant regarding this ethics board. I'm not saying that anything is necessarily nefarious, but when boards meet and speak with individuals, like, for example, executive session, and I don't see any reading of the charter or code that would allow an executive session of this board. That's really for the Board of Commissioners. But if there was separate meetings or separate conversations going on between the solicitor and members of this board individually, that is something very important to disclose, at a minimum to disclose, not at the end of the meeting, just in response to in my opinion, a rehabilitation question after a request was made by my client for this board to take a vote as to whether they would like Mr. Rice to stay. What this board does and this process leading up, in terms of when it meets, even if you don't want to get in as to what you actually talked about during that meeting, that has to be part of the public record. Has to be part of the public record that you at least met. We know that from Board of Commissioners meetings. When they meet in executive session, they come out and they say, this is why we were in executive session. It was for litigation, or it was for personnel. Personnel being not commissioners, incidentally, under the code, but at least it's announced. Tonight, there was nothing like that on the agenda that was published on Monday. So I would just say, going forward, please be mindful of that. Thank you.
Thank you. I appreciate that. Are there any other public comments? Seeing none, we'll go on with the rest of the agenda. The next item 3 is the acceptance of the complaint for the ethics review. We received a complaint that was dated March 28th from Christina Peroni, and there have been amendments to the complaint of April 11th and April 18th. And that is there a motion that we accept this complaint for the board to investigate?
I'll move that we accept it.
Thank you.
I'll second.
Second. Good. Is there any discussion about the process of accepting the complaint?
I'll start the discussion. I mean, people who know me probably know that over an hour and a half in a public forum, I'm not often quiet for that length of time. And I think the public, I'm personally uncomfortable up here with the fact that this board has not met in 11 years, 2003, and then one time prior to that, 1995. I think Radnor citizens expect more than that. At the same time, I'm very cognizant of the comments from the gentleman about the financial services industry. I'm not a lawyer, I'm in the financial services industry, and I am very aware of not just a conflict, but the appearance of a conflict. Those words I don't think appear in the Township Charter, but the words above reproach do, and it's, I think, quite analogous. On the other hand, we do have rules that were established, for better or for worse, in 1995. I don't know what happened in 03, but they are there, and I think it's important to follow rules. I think it's also important to be fair to all the individuals involved, not only the citizens of Radnor who expect a high standard, but also the individual to whom the accusation is made, against whom the accusation is made. We are meeting for the first time. We have read the complaints thoroughly, all of us. On the other hand, we've had no opportunity to really delve into the facts and convince ourselves of what actually happened. And I think if I were writing the rules today, or if I were writing them in 1995, I might have said as well that that should be done confidentially, in fairness to the individual involved. Because if the accusations are unfair, and I'm not suggesting these are or not, but if they were, if in another case, it would be better for the township, for the citizens, that would be resolved quietly and confidentially without it becoming widely publicized. It's just not fair to an individual's reputation. I am convinced, at least in my own case, that this will be conducted fairly and objectively, and that's my intent. With regard to the Mr. Rice issue, I don't know if we'll have a vote on it or not. I will say to everyone that it's not an issue that we're insensitive to. We have discussed it. We're very aware of it, and I think we'll just have to see how it plays out. But we are not insensitive to that issue. That's all I had to say. By the way, if the comments are directly related to this, I will be voting in favor of the acceptance.
Very, very good. Thank you, Martin. Are there other comments regarding the acceptance of the complaint? That being said, we'll take a vote then. All in favor of accepting the complaint for further inquiry, please say aye.
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 All opposed? It passes that we will accept the complaint and we'll go forward under the rules and regulations. The next thing is the initiation of the preliminary inquiry. As part of the acceptance of the complaint, the next step in the process would to begin a preliminary inquiry, and that I have a motion that we proceed with the preliminary inquiry.
I'll move the we.
Thank you. Is there a second?
Second.
Very good. Is there any discussion about the preliminary inquiry and what we will be doing to go forward with that?
I would just make a suggestion. This has been widely reported in the press for reasons that have been discussed. It's not on the website because of these confidentiality provisions in our rules. We can debate that. We have debated it, but they are there. But I think there's a general awareness in the public of what this is all about. So to the extent that there are questions that people would like asked, or people that you think we should be interviewing, I think it'd be great if those suggestions were sent to us, to the chairman or to Mr. Rice, however is easier. Thank you.
Mr. Zinkowski is going to
Mr. Zinkowski,
be the
okay.
repository, or Mr. Stefano, of any further filings, and then they'll be distributed through his office.
Good. And I think, are there any other comments regarding the preliminary inquiry? Then we should take a vote. All in favor of the initiation of the preliminary inquiry, say aye.
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 All opposed? Then it passes unanimously that we will begin the preliminary inquiry, and that we will meet and come up with a process of people to invite and the whole steps, and our committee will put that together. Is there any other comments or items that we should do before adjournment tonight?
Mr. Chairman, if I may. What I would request is that anyone that has information or documents that were submitted to the board, both councils or anyone in the public, as a written statement, please submit those so that we actually will make those part of the formal record. So this way they will actually be attached to the minutes.
Great, thank you. And were there any other comments before we adjourn? That we were, just for your information, that we plan to adjourn to an executive session to talk about the next steps for the preliminary inquiry. So we will be doing that subsequent to the adjournment of the meeting. Is there a motion that we adjourn?
Motion to adjourn.
Is there a second?
Second here?
Thank you. And any discussion? If not, then we'll take a vote. All in favor, say aye. Aye. And all opposed, no? We're done. Thank you very much. I do appreciate all the comments and the interest tonight. Thank you.